Okay, we're continuing here in the chapter on civil liberties in the week 3 module, depending on which class is watching this, but this is civil liberties. We're in the PowerPoint, beginning with slide number 8. Again, just a quick revisit of Caroline products. Don't get tripped up on the complexity of that, other than just know that footnote 4 of Caroline products, in that footnote, the court said that if the federal government is going to enlarge itself through the expansion of the General Welfare Clause, then the Supreme Court is going to begin to take on the side of discrete and insular minorities, okay? Minority groups where the first 10 amendments have been violated, they're gonna begin to favor them, okay? They're gonna try to balance things out. And again, remember, that's almost virtually the same argument that the Anti-Federalists made as they saw the size and scope of the federal government getting bigger. They clamored for a Bill of Rights, okay? Same argument. That'll help you if you go to answer one of the discussion post questions that direct that, okay? So if you go to slide number 8, you can kind of see the different civil liberties based on the Bill of Rights, okay? First Amendment protects freedom of religion, or I would say freedom of conscience, freedom of speech, freedom of assembly, freedom of press, freedom to petition government, okay? Is the First Amendment important? Yeah, okay? What have we gone through in Michigan over the last 3 months, okay, with the pandemic? We've had our freedom of assembling in school, assembling at the sports arena, right? Assembling in a restaurant. It has been taken away from us, hasn't it? Right? Now, it's for a good reason. What happened with this is called a neutral law of general applicability. It applied to everybody, so it's not getting discriminated, okay? And can government do that in extraordinary circumstances to protect lives? Yeah, that's what they're doing, okay? So that's the First Amendment. Second Amendment, obviously the right to bear arms. Third Amendment, no quartering of troops in times of peace. Hopefully that'll never happen. That's not a good thing. Fourth Amendment, protection against unreasonable searches and seizures. Fifth Amendment, protection against self-incrimination, double jeopardy. Fifth Amendment also, there's another section of it, deals with something called eminent domain. It allows the government to take your property for a general public purpose, as long as you're compensated for it with the fair market value of your property. Sixth Amendment, you have a right to a jury trial, a right to an attorney, a right to confront your witnesses. Seventh Amendment, suits in common law over $20. That's all of them pretty much today. Jury trial is preserved. No fact tried by a jury will be re-examined in a court of the U.S., okay? In other words, that's your protection against double jeopardy. Eighth Amendment, protection against cruel and unusual punishment. Ninth Amendment, certain rights shall not be construed to deny or disparage others retained by the people. 10th Amendment, powers not delegated to the U.S. by the Constitution or prohibited by it to the states are reserved to the people, okay? That is our civil liberties, okay? So if you're an attorney, dealing with protecting people, okay, a lot of times you're dealing with these types of issues. You're dealing with the Bill of Rights, okay, at least the first 10. If not the first 8, for sure. You're dealing with these all the time, okay? If you go to slide number 10, this is important, okay? Originally, the Bill of Rights dealt with, it only applied to the national government, okay? Congress shall make no law prohibiting the establishment of religion, okay? Congress is the federal government, okay, not the state government. All right, so it originally just basically prohibited the federal government from doing that. It did not prohibit state governments from doing that. Okay, so there was a court case that basically stated this in 1833 called Barron versus Baltimore. Okay, it says this: the first 10 amendments contain no expression indicating an intention to apply them to state governments. Thus, Bill of Rights had very little meaning in the daily lives of ordinary American citizens because state governments had authority over most of the activities in which individual rights were an issue, okay? That began to change after the Civil War and the passage of the 14th Amendment, okay? Within the 14th Amendment, it says, no state shall prohibit equal protection or privileges and immunities or due process. No state shall, okay? Because what was happening in the 1820s, 1830s, 1840s, 1850s, up to the Civil War. States were abridging the equal protection rights of African Americans. States were abridging the due process rights of African Americans. States were abridging the privileges and immunities of African Americans. So the 14th Amendment sought to address that, okay? The 14th Amendment was created to specifically deal with the rights of African Americans. It was never designed to be expanded beyond the rights of African Americans. Again, we already talked about in the last chapter, about how the courts in the 1860s, 1870s, 1880s rather, began to expand the rights of the 14th Amendment definition of persons and said that corporations are persons, okay? But that's not what the framers of the 14th Amendment designed it for. It meant specifically for the freed African American slaves. What the framers thought was, if you want to expand it to other groups, get your own amendment, create your own amendment. Okay, it was never meant by the court, it was never designed by the framers of the 14th Amendment to expand beyond freed African American slaves. However, the court took it upon itself to start interpreting it the way it thought it should be. Again, this is part of the challenge. In fact, this is the reason why I wrote the book that I wrote, Clashing Worldviews in the U.S. Supreme Court, because we address this in chapter 4 of the book pretty heavily and kind of show why we came to where we came and why this is going on and why that can be problematic, okay? So what the court began to do is selectively apply the Bill of Rights to the states. Even though Barron versus Baltimore in 1833 said you couldn't, after the Civil War, the court began to do that. That process of applying the Bill of Rights to the states and striking down state laws that prohibit certain rights is a process called selective incorporation, okay? So if you look at slide number 12, again, this is the section of the 14th Amendment that applies here, okay? It says, all persons born or naturalized in the United States. That word person, you might want to underline that or just remember that, okay? That word persons meant the freed African American slaves. Did not mean corporations, did not mean gay people, did not mean the rights of women to have an abortion. Okay, it didn't expand. In other words, the framers thought if you want to expand this, you better get your own amendment. They never granted or never wanted the courts to take it upon themselves to expand that definition. So it says all persons born or naturalized in the United States are subject to the jurisdiction thereof and are citizens of the United States and of the state in which they reside. Again, giving the freed African American slaves citizenship status, conferring that upon them. And then it says, no state shall make or enforce any law, okay? That is the loophole, the bridge, the gap that the Supreme Court goes through to start applying the Bill of Rights to the states. They said, see, no state shall, so this state law is illegal, and this state law is unconstitutional, and this state law is unconstitutional. Okay, you just have to, that's where they get that from. So if you go to slide number 13, you can see where some of the first cases in which the court began to expand the 14th Amendment's definition of person to other situations, okay? So this is free speech rights. This is slide number 13. So in Gitlow versus New York, Fiske versus Kansas, the court began to invalidate state laws that restricted expressions of free speech. In Nair versus Minnesota in 1931, it struck down state laws that prohibited the press. In Hamilton versus Regents, the University of California dealt with religion, okay? In DeYoung versus Oregon, assembly and petition, okay? Why these are significant, okay? Again, you don't have to remember all these. I'm just trying to show you what's going on. Is the court, again, began to go through that persons section of the 14th Amendment and said, hey, persons, and it went through the no state shall, okay, and said, that, listen, okay, then states that are abridging the Bill of Rights rights of citizens in Michigan or pick your state, these are unconstitutional. The court began to, if you look at slide number 14, selectively incorporate the Bill of Rights to fair trial rights. So in Mapp versus Ohio, evidence acquired through an unconstitutional search cannot be used for conviction in state courts. So in other words, somebody can't just randomly, the police can't just randomly just kind of break into your house, find some evidence against you without a search warrant, submit it to court, and convict you. Okay, that's a violation of your rights. So in other words, as I'm talking about this, it's like a double-edged sword. Okay, on one hand, you can see where they're trying to protect the rights of citizens, but on the other hand, they are, as I say, they're twisting the Constitution up into a pretzel to make it confer rights that the 14th Amendment was never designed to do. So again, it's kind of a good news, bad news kind of thing. Gideon versus Wainwright, defendants in a state criminal proceeding must be provided a lawyer in felony cases if they cannot afford one. Okay. Malloy versus Hogan, you cannot be compelled to testify against yourself. Again, that dealt with police coercion, where police were, taking someone in a back room and coercing them. Bright lights, dark room, lots of smoke, lies. You better tell me the truth, okay? They prevented the police from doing that. So, again, many of these were reforms that needed to happen, but the means by which the court did it sidestepped the original interpretation of the 14th Amendment. Miranda versus Arizona, again, most of us know that one if you've ever watched a cop show, right, on TV. You have the right to remain silent. You have legal counsel at the time of arrest. Again, these are all selectively incorporating the Bill of Rights. And then there's other ones on, slide number 15. Pointer versus Texas, you have a right to confront witnesses who testify against you. Klopfer versus North Carolina, you must be granted a speedy trial. You ever thought about that? What constitutes a speedy trial per the Supreme Court? And the answer is 100 days, okay? In other words, you can be held in jail for up to 100 days and not have your constitutional right to a speedy trial violated, okay? Interesting. Duncan versus Louisiana, you have the right to a jury trial in criminal proceedings. Benton versus Maryland, you cannot be subjected to double jeopardy. In other words, you cannot be tried for the same crime twice. Okay, so again, this is selectively incorporating the Bill of Rights using the phrase in the 14th Amendment, no state shall, and thinking, hey, that applies to state governments, okay? Overriding the Barron versus Baltimore decision of 1833. Okay, I'm going to stop there.